We've got breaking news when it comes to the Epstein Files and the Ghislaine Maxwell files, because don't forget, Ghislaine Maxwell just as culpable, if not worse sometimes, as Jeffrey Epstein when it comes to child sex predation, child sex abuse, child sex trafficking. Anyway, a federal judge, Judge Paul Engelmeyer in the federal court system in New York, in the Southern District of New York, has entered a 24-page opinion and order today stating that the grand jury materials that have to do with Ghislaine Maxwell's prosecution in the Southern District of New York are going to be turned over. He added a couple of kind of new caveats to how these records are going to be turned over, but I want to walk through this order with you because I think it's important to have the proper context of kind of what can we expect to see and why is this order being entered at this time. So again, it's a 24-page order and it's from Judge Paul Engelmeyer. Now, this is the judge. He was not the one who presided over Ghislaine Maxwell's indictment. Two, by the way. There was an original and then there was a superseding an indictment, and that becomes relevant when we talk about the grand jury records. But there was another judge who actually presided over Maxwell's jury trial. Just a reminder, Ghislaine Maxwell did go to a jury trial before a jury of her peers, and she was found guilty, convicted, and sentenced. But Judge Engelmeyer has been handling the motions and kind of like the post-conviction issues that have arisen in Ghislaine Maxwell's case. And he makes it very clear at the outset that the Department of Justice has moved on an expedited basis to get an order that would enable it to publicly release two categories of records from Ghislaine Maxwell's case that the DOJ contends are within the scope of the Epstein Files Transparency Act. That is a law that was signed by convicted felon Donald Trump on November 19th, 2025, that requires the Pamela Joe Department of Justice to turn over all, and in very broad language, all documents, records, etc., that have to deal with Epstein and Maxwell and others. Now, first, the DOJ asked the court to rule that the Epstein Files Transparency Act covered the grand jury transcripts and exhibits in this case. Judge Engelmeyer refers to all of that as the grand jury materials, and that act, the Epstein Transparency Act, overrides the Federal Rule of Criminal Procedure 6E. Y'all have walked through that Federal Rule of Criminal Procedure with me here at the Katie Phang News Channel. Why? Because on various occasions, Pamela Joe's DOJ has asked to unseal these grand jury records, and in Florida and in two federal courts in New York, those motions were denied. Judge Engelmeyer stating in a previous order, because of this Federal Rule of Criminal Procedure that militates towards secrecy and confidentiality when it comes to grand jury materials and records, I'm not going to turn over these records. I'm not going to allow them to be turned over. But I will remind you that this judge and another federal judge, Judge Berman in the Southern District of New York, who was dealing with Jeffrey Epstein's criminal prosecution that was abruptly ended when Epstein mysteriously died, both of those judges called out Pamela Joe's DOJ stating the following: there is not a lot of new information that's going to come from these grand jury materials. Judge Engelmeyer and Berman also saying that the DOJ is playing fast and loose with misleading the American public to think that there's some amazing, just dropping information that's in these records, and that really the bulk of the information that hasn't been publicly disclosed so far is held by the DOJ, and the DOJ should be turning over its records. Anyway. Secondly, the DOJ is asking Judge Engelmeyer to rule that the Epstein Transparency Act covers the extensive discovery that the prosecution provided to the lawyers for Ghislaine Maxwell in connection with her 2021 jury trial, and to modify a protective order that was entered that protected that discovery from being publicly disclosed. The court grants the DOJ's motion, but then also entered again two specific caveats that I want to walk through with you because I thought that they were particularly ingenious by Judge Engelmeyer. In the order, the judge walks through the procedural history of this case. In June of 2020, a grand jury indicted Ghislaine Maxwell on charges arising from her facilitation of and participation in a scheme by, quote, notorious pedophile Jeffrey Epstein to abuse multiple minor girls. On March 29th of 2021, a different grand jury returned a superseding indictment that added related charges. So that's two separate grand juries, folks. So there will be at least two separate sets of grand jury materials that will be turned over here. Maxwell's jury trial began on November 29th of 2021. It ended on December 29th of 2021. During the course of that multi-week jury trial, there was evidence that was publicly admitted, that was heard, that was publicly revealed. That came from testimony from 4 victims, that came from individuals who worked for Epstein and Maxwell, testimony of law enforcement, and corroborating physical and documentary evidence. Keep that in mind because that does become relevant in a little bit. After resolving the post-trial motions, the prior judge, Judge Allison Nathan, who now sits on the Second Circuit Federal Court of Appeals, Judge Nathan sentenced Ghislaine Maxwell to 240 months of federal imprisonment. As we know, Maxwell appealed. The United States Circuit Court of Appeals, the Second Circuit said, we're affirming your conviction. And then the Second Circuit denied her petition for rehearing. And then just this past October 6th of this year, the United States Supreme Court denied Ghislaine Maxwell's petition for certiorari, meaning the Supreme Court said, we're not taking your appeal any farther, Ghislaine Maxwell. Now, as I said, previously, this judge denied the DOJ's motion to unseal these records back in August of this year. Now, I want to harp a little bit, on the language that comes from this order on page 4. Judge Engelmeyer calls out the DOJ and says the following. The reason why I denied it back in August, and of course this is before the Epstein Transparency Act, are these 2 major reasons. 1, contrary to what Pamela Jo's DOJs wanted to say, the grand jury materials would not reveal new information of any consequence. The 2 grand juries met briefly. They each received evidence on a single day. They did not meet to investigate, only to return an indictment, and the only testimony they heard was summary testimony from 2 law enforcement officials. With minor exceptions, the evidence before the grand juries was already a matter of public record, largely as a result of Maxwell's 2021 trial. So again, Engelmeyer underscoring why disclosing these grand jury materials concerning Ghislaine Maxwell and the 2 grand juries that sat to indict her, this is really not going to be some new bombshell information that's going to come out. Secondly, Judge Engelmeyer said back in August that there was a multi-factor test that was set forth in precedent in case law, and really it weighed overwhelmingly against disclosure. That's the reason why back in August, Judge Engelmeyer said, I'm not going to release these grand jury materials. Notably, the DOJ did not appeal his decision. Now, on November 19th, Congress passed and Trump signed into law the Epstein Files Transparency Act. And as we know, there's a 30-day tick-tock deadline for the DOJ to comply. So ostensibly, December 19th, we should be getting the Epstein files released by the DOJ subject to certain exceptions, right? But there are permitted withholdings, 5 distinct categories of records that allows Pamela Jo as the Attorney General to not turn over certain documents. The AG may withhold or redact segregable portions, meaning there's certain 5 distinct areas that allow Bondi to not turn over records. Notably, none of those 5 includes the records here, the grand jury records dealing with Ghislaine Maxwell's case. Now, let's fast forward to the following page, page 9. The categories of materials to be publicly released subject to withholding, again, to those 5 categories, the DOJ has listed below based upon its initial review. And so this is the DOJ listing out on page 9, running into page 10 of this 24-page order, what the DOJ, based upon its initial review, has said, subject to the withholding of those 5 categories, it will be releasing pursuant to the Epstein Files Transparency Act. You can read it for yourself, but I want to highlight a few of the bullet points. 1, financial records will be disclosed or should be disclosed. Bank records, credit cards, credit reports, credit card records, credit checks, brokerage, investment accounts. Follow the money, people. When you follow the money, it can lead you to new abusers, new co-conspirators, new people that had their hands dirty, knew or should have known what Maxwell and Epstein were doing. Travel records, commercial airline records, private airline passenger manifests, online booking records, etc. We've seen some of them come out courtesy of House Oversight Dems, but otherwise this is also information that could be disclosed, that could show people that were complicit, that participated, that knew or should have known what the hell was going on with Epstein and Maxwell. Search warrant returns, emails, photographs, materials obtained during physical searches of properties, right? Safety deposit boxes, safes, electronic searches of computers, telephones, and other electronic devices. photographs and videos of relevant properties and locations, Epstein properties, Maxwell residence, etc. Right? These are some of the most important things that are going to be released, including materials obtained from the Palm Beach Police Department and the U.S. Attorney's Office for the Southern District of Florida, including reports, photographs, and videos. Okay, so this is what the judge ended up doing. The judge says, number one, the Epstein Files Act trumps, no pun intended, that federal rule of criminal procedure that otherwise says that you cannot turn over grand jury materials. Okay? Number two, that protective order that was in place during Ghislaine Maxwell's criminal prosecution, it is modified to add extra protections to protect the victims and survivors of Epstein, Maxwell, and others. Why? Because Judge Engelmeyer makes it clear that Pamela Jo's DOJ sucks and that they have done nothing to try to help the victims and survivors in this case, and that they have done nothing to continue to aid in protecting the identities of the victims and the survivors of this case. So let's get to that language that I want to share with you. So here we go. The protective order that previously governed the discovery in Ghislaine Maxwell's criminal case has been modified the following way. Nothing in this protective order shall prohibit the government from publicly releasing materials whose disclosure is required by the Epstein Files Transparency Act. The restrictions of this order, however, remain in place with respect to the segregable portions of records that contain personally identifiable information of the victims or victims' personal and medical files and similar files, the disclosure of which would constitute a clearly unwarranted invasion of personal privacy. So that has been added to the existing protective order, and the DOJ has stated it's going to work with the relevant U.S. attorney's offices to make appropriate redactions of victim-related and other personal identifying information. Now, in a normal world, in a non-Pamela Jo DOJ, that affirmation or that kind of statement or reassurance by the DOJ would normally be sufficient. But of course, we aren't operating in the world of normalcy anymore, right? The presumption of regularity, as I talk about all the time here at the Katie Phang News Channel, doesn't exist anymore. It is now the presumption of irregularity. And because it's a Pamela Jo DOJ, what do we know? We know incompetence, we know cruelty, and we know an inability to do the right thing. And so that is why the Judge Engelmeyer, in his order, calls out Pamela Jo's DOJ the following way. Because the victims are seeking the court's assistance to ensure that their names and identifying information are protected, the court is modifying the protective order to put in a reliable mechanism to guard against disclosure of their names and other identifying information and any discovery subject to that order. Now, I want to add right now that part of the reason why I am fighting as hard as I am doing is because I used to prosecute these types of cases. And it is so hard to have victims and survivors of sexual abuse, especially children, to come forward to tell their stories. We do not want to dissuade them from coming forward. We want people to feel confident that when they work with prosecutors and law enforcement agencies, that they will get the support that they not only deserve, but are legally entitled to. And that is the reason why protecting their identities when they do not want to be disclosed is so critically important, and why those failings that started with the U.S. Attorney's Office in the Southern District of Florida piss me off. They should have been notified back then in mid-2000 that that sweetheart plea deal was being negotiated with Jeffrey Epstein. They had zero say, but 100% stake. And that is just dead-ass wrong. These victims and survivors of Epstein and Maxwell and others have been wronged repeatedly by the system, by the perpetrators, and by, frankly, people that have money, means, and influence to protect themselves. Let's not protect the actual victims in this case. Let's protect ourselves. The victims' concerns regrettably have a basis in fact. In its 2 rounds of applications to this court to disclose records, the DOJ, although paying lip service to Maxwell's and Epstein's victims, has not treated them with the solicitude that they deserve. The court has chronicled in denying the DOJ's previous motion that the motion itself misled victims and the public at large in holding out the Maxwell grand jury materials as essential to the goal of transparency to the American public, when in fact the grand jury materials would not add to public knowledge. The DOJ has acted without notice to Maxwell's and Epstein's victims. This court and Judge Berman, the Jeffrey Epstein judge, were compelled to direct the DOJ to notify victims of its latest motions and to set a deadline for victims to make submissions. So, the court has now done the following second thing in this order. The modification of the protective order will include the following. The United States Attorney for the Southern District of New York, Jay Clayton, will personally certify that the material has been rigorously reviewed to be in compliance with the specific subsection of the Epstein Files Transparency Act that requires protection of the victims against revelations of their identities or invasions of their privacy. Okay? And here's the language of that specific modification of the protective order. Prior to the release of any records covered by this protective order, the U.S. Attorney's Office for the Southern District of New York, or specifically, the United States Attorney himself, shall personally certify in a sworn declaration filed on the docket of this case that these records have been rigorously reviewed for compliance and that none of the records to be released contain personally identifiable information of victims or victims' personal and medical files and similar files, the disclosure of which would constitute a clearly unwarranted invasion of personal privacy. Ladies and gentlemen, that requirement is huge. It means that Jay Clayton, as the U.S. Attorney for the Southern District of New York, must certify under oath that he has reviewed all of the records prior to them being publicly disclosed and that he himself is assuring the court and the public and the victims and the survivors that none of that personal identifying information has been disclosed. May I remind you as well that Jay Clayton is the lawyer that Pamela Joe has appointed to investigate the Democrats that have been identified in the Epstein files, which is going to create a whole other legal issue when it comes to the release of these records, because an open criminal investigation is one of the things that you bet your bottom dollar Pamela Joe is going to rely upon as a basis not turn over the records in this case. As a very quick note, the Southern District of Florida concerning Jeffrey Epstein's grand jury records, that federal judge, Judge Rodney Smith, has also entered an order granting the motion to unseal the grand jury transcripts. It is a bare bones 2-page order, definitely not 24 pages. It basically says the Epstein Files Transparency Act trumps the federal rule of criminal procedure that deals with the secrecy of grand jury materials. It's interesting to see because we don't really have a full understanding of what was presented to the grand jury, if anything, in Florida. And we don't really have a lot of illumination or insight into that. So I'd be curious to see what gets released. People, we are on this. I am on this. I am also on a campaign to hit 500,000 subscribers here at YouTube before the end of 2025. If you haven't subscribed, hit that subscribe button. I'm appreciative of the support. I'm so glad we're on this journey together. And I always encourage you to be mad, be outraged, and demand accountability because you know I, right as rain, am doing that for all of you. Katie Phang here. We launched the Katie Phang News Channel in partnership with the Midas Touch Network so we could bring you the latest in legal and political news. Straight, no chaser. So if you're a fellow truth teller, hit that subscribe button and share the word about this channel so we can build a high information America together.